in Criminal Appeal 148 of 2020.
From the facts and circumstances discussed above, the intention of the appellant to cause death or even that he had the knowledge that death in all likelihood would be caused by the injury inflicted cannot be readily inferred. Under the aforesaid facts and circumstances in the discussions, we are of the view that the impugned judgment so and so is required to be modified and the conviction is liable to be altered to one under 304 part 2, 7 years. The citations will be returned to you. We have made it a practice. No point having those citations. Okay, to the respective council. Now, paper book prepared?
No,
Not prepared. Okay, next week. Next Monday. Written objection in which IA? Okay. On a prayer made by MSR Wrongmay Learned Counsel for the response number 2. The matters and are adjourned by 2 weeks to enable her to file objection in the IA. Yes. 1-3.
Yes.
13.
Yes, you must. And taken consent from other side.
Yes.
I don't know for the paying.
Yes, you are for the petitioner.
Okay.
Okay. You want adjournment?
Yes, sir.
How many days? We'll have it on next Tuesday, the next Wednesday. Okay. After a week. Okay. A prayer for adjournment has been made on behalf of the respondent number 4.
Yes, sir.
By the Learned Counsel appearing for the respondent number 4 on behalf of the Learned Counsel appearing for respondent number 4. Para. List. The matter is accordingly adjourned to be listed on Wednesday next date. Okay.
I love it. That is fine. Hello, in 10 seconds, paper.
Item number?
Item number 14.
1-4. Yes, what is your prayer? Has not been served. You are for the petitioner.
Yes.
Appellant.
We have received it.
What is your name?
Zero.
G.
Zero.
Boro on behalf of as the Sri G. Boro Learned Counsel appearing on instruction of Sri as the Learned Counsel for the appellant has submitted that copy of the paper book is yet to be furnished. The Learned Counsel is accordingly directed to coordinate with the office for collection of the paper book, and the matter will be listed for hearing after 2 weeks. Miss, prepare. Be here, Learned APP. Assam is present. You collect it. Okay. Item number 14 on 4.
Item 1. Service was completed. And lots of can it be taken up after the week?
After 2 weeks, sir.
Thus you are paying for R2. Okay. Have you received paper book?
We have.
Oh, no, Mr. Das, okay.
He of degree-
Heard three AU Chaudhary, IU Chaudhary, learned counsel appearing on instruction of Sri Ahmed, learned amicus curiae for the appellant. Also heard Miss B. Bhuya, learned APP Assam, whereas Sri N.J. Das, learned amicus is present for the respondent number 2. Where do the learned counsel for the appellant and the learned APP has acknowledged receipt of paper book, comma, Sri Das, the learned amicus for the respondent number 2, has informed that copy of the paper book has not been furnished to him. Para. Sri Das is accordingly directed to coordinate with the office for collection of the paper book.
This is a report as you know, you can juvenile justice agreement against the bill before one objection.
You know, in hearing the appeal, since the case, since the appeal is right for hearing, RIP, the same may be listed for hearing after 2 weeks.
Document reached the date after it.
2 weeks you have said, let's see. Who will be the bench? We corrected today, itself. Item number 2. Madam, why is it listed for order? Now, why is it listed for order? Record the issue. Record the issue. Anna. None appears for the appellant on the call, whereas Ms. H. Jahan, learned APP, is present for the state respondent. Para. This appeal was admitted on 2/6/2023 and records were called for. Office note dated 25/4/2025 has however reflects that the TCR have not been received. Para. Office to give requisition for transmission of the TCR expedition list after receipt of the reports.
Eventually,
Yeah.
Also, the council is not sure. Otherwise, regular.
What about R2 in this case, Boxo, madam?
Everyone is here, perhaps the services from company.
No, you have to receive, you have to get the instructions. Okay. None appears for the appellant on call. Sarah? Whereas Ms. H. Jahan, learned APP, is present for the state respondent. Sarah? This appeal was admitted on 24/7/2023 and records were called for which have been received. Sarah? As regards service of notice upon the respondent number 2, Ms. Jahan, the learned APP, prays for and is granted 2 weeks time to obtain the instructions. Para. Since the TCRS have been received, office to go ahead with the preparation of the paper book. Okay, TCR we have said.
I didn't know. I was the working director.
We corrected ourselves sometime back, few days back.
Try for records instead of lower court.
It is a judicial order, judicial order.
item 4 and 5,
Yes. Where the paper book is there, we can have this for hearing. Is there any private testimony?
Or no?
No, there is, why no?
302 cases. Testimony is not.
Heard Sri I.U. Chaudhary, learned counsel for the appellant, as well as Ms. Raj Jahan, learned APP Assam, Para. Since the paper book has been prepared and furnished to the learned counsel, there is a joint request for fixing this matter for hearing. Accordingly, we direct the matter to be listed for hearing in the second week of June 2025.
Okay.
Item 7,
Seven, madam. Gustav, Mosari, yes,
So, Dr. Puji, see the order dated 25/10.
yes, question, yes.
Mrs. K. Pepper has appeared on behalf of the respondent.
Hmm.
You know, the record has also come, you know, it may fix up for again.
Yes. Yes, what do you say, madam?
It's a legal,
Hmm?
the fix up for again.
Ma'am, this matrimonial appeal,
Yes,
how many witnesses are there?
I think only two.
Two witnesses. Please assert it.
Yes.
And madam, how many witnesses? Where is your brief? Should carry the brief, don't come like this. Have the brief, it's not so difficult a job to have the brief in your hand. Now, Mr. Doctor, why we are asking is that we can dispense with the requirement of a paper book and we can direct the registry to make copies of the deposition and the material exhibits if any. Therefore, we are asking how many
Well, the plaintiff evidence 3 and dependents or
and documents, any documents?
documents will be there.
Heard three as Dr. Leonard, Senate counsel for the appellant assisted by Ms. Mosari. Also heard your name and Kalita on behalf of MSK for Leonard counsel for the sole respondent. There records have come pursuant to the order dated 25/10/2024 by which the appeal was admitted. The TCR have been received. Sarah? Both the learned counsel have made a joint prayer for fixing the date, fixing the appeal for hearing. Sarah? We accordingly direct the office to make copies, photocopies of the deposition of the plaintiff as well as the defendant, and also of any documented evidence from the records, and serve set of the same to the concerned learned counsel. And thereafter, the matter, the matter may thereafter be listed for hearing in the second week of June 2025. The name of Ms. K. Phukan be reflected in the call list.
item 8,
Yes.
And matrimonial appeal.
Hmm.
When taken into the respondent has appeared.
Okay, yes.
record without
Hmm.
NCRA document.
We can pass the same order if you are agreeable. We can have the, how many witnesses?
Proceed to portable for witness.
Two from you,
3 from us, your lordship.
one.
And one.
Okay, same order. We'll have this for hearing in the second week of June. And second and third week of June. And in the meantime, the position's copy would be made by the office and given to both the parties as well.
There's an IA, your lordship.
Yes.
They have held a counter claim for restitution of conjugal right, that has been allowed. I'm praying for the IA for stay of death for the restitution of conjugal right.
Your case is for divorce.
Yes, your lordship, because
That has been rejected. and you are aggrieved, then come to this court for as an appellant. In the, huh?
I also filed complaint.
No, understood. And in the meantime, a counterclaim was filed for restitution. That has been decreed. Have you gone for execution?
No, man.
Don't go for execution. Do you know how restitution consequential rights is executed? How?
Till by extent of property
And
civil person.
you don't go for that. You cannot be forced to live together, but you can be sent to jail. So don't go for execution. Okay, we are not passing in at this stage. The three H. Buragohan, Learned Counsel for the appellant, has submitted that the IA has been filed, the connected IA has been filed against for stay. But where is your appeal? You have to file an appeal. Appeal is what? For what?
For
Appeal is for rejection of your
divorce.
divorce. Where is your appeal for the restitution?
Filed.
Unless there is an appeal, we cannot stay here.
Cannot. That must be good.
You have to file two appeal. You file an appeal, we'll take care of that. Okay. It may be even by the same judgment, but cause of action are entirely different. Okay. We'll not say anything. Okay.
My lord, it may be good.
Yeah, we have said that. In the 30th of June. Or Baki Nekati. If you want to file an appeal in the meantime, it will come on its own. It has got nothing to do. Orders are required to be passed now. You can take it if you file it.
Then 9.
9, yes. Dr. Kulita, what is this?
My lord, probably that for the barrister will be one minute now.
Which ball? Cricket ball or tennis ball? IPL ball? Or football? Yes, mister. What sport you are interested in? Tennis or cricket or football? So the football is with you.
The suit was filed for declaring marriage under section 11 to be void. There is that, section number 1 has a legally found at the time of marriage.
That has been rejected.
That has been rejected on the ground that they had an agreement for mutual divorce, where there is no single word uttered to restrict to having a spouse living at the time of marriage, because they wanted to dissolve the marriage for the mutual differences.
Now, why is he aggrieved? The divorce has been rejected.
It's not a divorce, they have filed for nullity of the marriage.
Nullity, oh, that has been okay.
And they, it was, the suit was decreed against them because they had an agreement which was executed by the.
Okay, now what is your take? You have appeared for this for number 1.
Number 1.
Records have come.
That was a problem.
Appeal admitted.
Relatively short.
You can have the same thing if you are agreeable. You can have it for hearing.
Yes, yes.
Hearing.
And after the 19th June,
We'll have it in the 3rd week of June. 3rd week of June. In 3rd week. How many witnesses were given by your side? And
No witnesses.
Okay.
We have only filed witness statement after that.
After the-
witness statement, the pleadings are part of the appeal. Appeal memo contains the pleadings.
updating is not actually.
No, no,
Just
the-
only happy.
They have annexed the document.
No, not the document. The pleadings which you have filed before the court and by the other side, are those pleadings
Again,
part of the?
Then the part of it.
Okay, then only the reposition part, same. Okay, 3rd week of June. The repositions will be made copies for the sake of convenience and handed over to the learned counsel, okay?
Right.
Then
Yes, Mr. Sharma.
Then we have talked about
LCR has come.
Makes sense.
it.
This appeal was admitted on 18/11/2024. And Shri M. Sharma, learned counsel, was appointed as an amicus who is present today. full stop. Both, there. Involving POXO or what?
Also. Okay, good.
As regards service upon the respond number 2, there is a service report as per which the respond number 2 appears to have been served. Full stop. Office note dated 24/4/2025 reflects. No, the notice, the records. Records have come or not?
Yes.
Office note dated 19/12, 19/12. Reflects that TCR have been received. Para. Office is directed to prepare the paper book and list this case for orders after preparation of the same. Para. If in the meantime, the respond number 2 does not appear, comma, this court would appoint an amicus curiae as the sentence and conviction involves the POXO Act.
That was actually filed together, so now it is bifurcated. It was filed together.
Mayor, item number 11, this criminal appeal 434 of 2024 was filed for another 2 accused along with this. Now, as per the last order of the Honorable Court, criminal appeal number 1790 of 2025 and criminal appeal 1835 of 2027. Both this, we have now filed separate applications for that appeal. Because there the conviction is only for 8 years and now it is listed before the single judge jury. So your lordship kindly note the criminal appeal number 1790 of 2025 for Sohrab Ali, Sohrab Ali.
First
And-
one, the first appellant.
Yes, and then criminal appeal number criminal appeal number 1835.
Now what do you want to do? What orders
But
are
your
you?
lordship kindly observe that so far Sohrab Ali and Anwar Hussain.
No, that will do. Then thereafter consequently.
Thereafter, well, she has to file her objection in the bail petition of the other accused. So as soon as the objection is filed, we will argue for the bail.
Import that prepared simply
Okay.
because we have
Okay.
bifurcated, so I.
Heard be the more learned senior counsel for the appellants as well as Miss Ed Jahan, learned APP Assam Para. Read more, the learned senior counsel has submitted that pursuant to the observations made by this court in the last order dated 19/12/2024, two more appeals have been filed separately for appellants Sohrab Ali being criminal appeal number
Criminal appeal number 1790 of 2025.
1790 of 2025 and
Anwar Hussain, alias Anwar Bepari, alias Anwar Bepari.
Anwar Hussain alias
Criminal
Anwar
appeal 1835 of 2025.
1835 of 2025.
So
And both the aforesaid appeals have been listed today before the honorable single judge. Full stop.
the names of these two appellants may be deleted from this.
That being the, we also heard Miss. What question you gave, question? In view of the aforesaid development, the names of the aforesaid two appellant be deleted from the present appeal. The office is accordingly directed to make the necessary corrections. So far as the IA is concerned, the learned APP has informed that the objection is ready and would be filed shortly. List after 2 weeks.
LCA has come, your lot will directly.
List after 2 weeks for consideration of the IA. Since we have been informed that the LCA, TCR have been received, office to go ahead with the preparation of the paper book in the meantime.
Yes, TCR will be requiring a single mention.
We'll furnish a copy of the. Once the paper
Once
is
the
ready,
paper book is there, it can be transmitted.
we can. But may I wait for a fix it,
2 weeks we have said.
any date after 2
Still we
weeks,
have to
fine.
amend it.
Any date after 2 weeks.
As requested list on today is 30th. 7, then we'll have it on 16th
16.
May. Is it okay?
Yes,
I'll find it tomorrow.
we are blessed.
Item 12.
Item 12. First time it has come. Oh, you, not first time, you are appearing. Miss P. Das, who is Miss P. Das? Miss P. Das.
59 days. I'm not objecting. I was not objecting.
But we'll condone it in her presence, okay? On Friday. None appears for the applicant on call. Whereas Ms. Ed Jahan, learned APP is present. Put further person to the notice issued on 9/4/2025, 3 S. Nawaz, learned counsel has entered the hearing for number 4. As per number 4. Oh, here am I, 3 S. Nawaz, learned counsel has been appointed as amicus for this for number 2. Be that as it may. Both the learned counsel for the respondents have fairly submitted that they would not have serious objection to the aspect of condonation of delay. Be that as it may, in absence of the learned counsel for the applicant, no orders are passed and the same is adjourned to be listed on Friday next.
Yeah.
Day after tomorrow. Or we can have it on Monday also. No, one is delay condemnation, Friday. Please inform her, we'll condemn it.
Item 17, appeals.
Yes, sir. Here I was supposed to get the instruction of service of notice on the respondents. I had spoken with the Nagaon police personnel. He said that he went there to the address, he found the relatives, but the relatives did not divulge where these people are. In fact, what he said is that they don't have very good relationship, and the mother and daughter, means Tamanna and her mother, had left for some Morigaon, some places at Morigaon. So they but are unable to get the proper location of the mother and daughter are. So in that case, sir, they are also not telling.
No, had the matter been an old matter, we would have straight away gone for appointing an amicus. Matter is of 24 and this criminal affair, this last order is of 2025. We try once more. We grant some more time, or further 3 or 4 weeks time. If you come up with instructions regarding the address and service, it's good. Otherwise, we'll appoint an amicus.
We can direct Morigaon police also
Yes,
to
yes.
search it.
Third, I.U. Chaudhary, learned counsel for the appellant, as well as Miss Ed Jahan, learned additional PP Assam, Sarah. Pursuant to the last order dated 28/4/2025, the learned APP has submitted that do the concerned, which Hannah?
Nogam.
Nagaon PS,
No, Nogam. Tamil, no. So, what do you know? But in Nogam.
under the concerned official, under the official to the concerned Nagaon PS had tried to serve notice. The neither the victim nor her mother
Was found. In the
were
given
were
address.
found in the given address, and the relatives were not cooperating in divulging their present address. Full stop. She has, however, informed that there is some indication regarding their present place of residence being at Morigaon. Full stop. In view of the above, further time of a month is granted to enable service of notice upon the respondent to full stop. Based on the developments, this court would explore the option of appointing an amicus curiae for the respondent to in case the respondent to does not appear. As the sentencing conviction involves the POCSO.
As far as appeal is concerned, I think NCR is here.
I said,
This year is.
yeah, since
NCR.
LCR is not, TCR is,
NCR is here.
since the TCR have been received from office to go ahead with the preparation of the paper book in the meantime.
15 for hearing.
Hmm? Okay, then what happened? Worked out? Anything worked out? Condition failed. Okay.
And Sachin, pehले, one side. I have received instruction as of today. Husband is ready to
Ready to?
accept. It's a second come. We are not corner.
No, you're agreed by what?
Lordship,
You,
3 years,
you are agreed by what is the grievance? Appellant, you are before us.
and lordship.
Why against what?
And the 51 days,
No, we are not on the facts. You are agreed by what order?
lordship. Rejection order,
Divorce. You filed for divorce. That has been rejected. You want a divorce. You want a divorce. And he doesn't want a divorce.
he's saying lordship, but it is not
That's
possible.
option.
I mean, he's submitting as per his instruction, lordship. I'm not.
What do you do?
Lordship.
What do you do?
I'm doing nothing, lordship. I'm living with my mother only.
Where do you stay?
Rupi.
And your client, what do you do?
I am a pharmacy.
You're a pharmacy owner.
Small pharmacy.
When was the marriage?
Marriage was on.
Whose part of the liability?
22. 22. Not even 3 years.
After 1 month, she left, lordship.
You left.
She left, I mean, driven out by the petitioner, I mean, respondent once.
Another carbine case. Not a carbine case. In your case, we have seen that there was also 340%.
More than two.
One is complete and someone is trying to develop. But in item number 2, my lord, the notice of conduct unserved. We have given the address of the private respondent as given in the petition. Which conduct as insufficient address. Which I can another chance in step 1. private respondent. Otherwise, item number one, the Mahdi there. That is sole respondent.
Who's P. Ahmed? Third, we are Mazumdar. Learned. You are sending consideration, education for the applicants in these two applications. Though the respondent in review petition 112 of 2023 has entered appearance and the name of the learned counsel appears in the cause list, there is no representation. Full stop. So far as review petition 137 of 2023 is concerned, the learned counsel is informed that those steps were taken in the address given in the writ petition, comma, the same has come back unserved. Full stop. He accordingly prays for and is granted time of a further week to take fresh steps. Full stop. Let these matters be listed after 6 weeks along with service report. Okay. That order will come. You can contact the earlier advocate if you, that will be, I think, helpful in the writ proceedings. Yes, Mr. Karan.
I didn't really, petition, also because of this petition, it's still complete.
Mm.
Because they transfer.
Have you filed any application and any affidavit?
Additional affidavit filed.
Okay, that will be enough. Explaining the delay.
Yes.
It is, yes. Part 3. S.C. Kyle. Learned. You filed a senior standing counsel, CBDT.
Yes.
Learned senior standing counsel, CBDT, comma income tax. Appearing for the applicant who by means of this application is paying for review of the order dated 16/12/2022 passed in a series of
Yes, 3 cases were there.
passed in 3 repetitions. Full stop. It is submitted that the Honorable Supreme Court in a subsequent decision has dealt with the issue and therefore the order passed by this court is required to be reviewed. As regards the delay in filing the review, comma, the none, do that. The aspect of delay in filing the review, though in a writ proceeding, was taken up for consideration. And the learned standing counsel has drawn the attention of this court to an additional affidavit filed explaining the delay. Full stop. Fair enough? Since it is the categorical case of the applicant that the Honorable Supreme Court in the case of Ganapati,
Thank you. Versus, there's a placement in.
in the case of Union of India and another versus Mrs. Ganpati Dealcom Private Limited, page 21, has settled the position. Mechanically.
Yes, it is a temporary case of the applicant.
No problem. Our case, a prima facie case appears to have been made a full stop. Accordingly, issue notice returnable by 4 weeks. let steps be taken for service of notice upon the opposite parties by registered post with any steps within 2 working days.
Similarly, passing item number
After number
4.
four. Two respondents. In both,
Yes.
here there are two opposite parties, there are also two opposite parties.
Okay.
Right. Same. And additional affidavit filed same day.
Yes, sir.
We were for and all that again. Nine, 22. Whereby people are allowed to receive payment against their supply work, but they have also paid for interest in the income. This was left out. This is like this will be agree with that.
Yes, what do you say, Mr.?
Otherwise, verification was done and then we invited.
What was the order cost?
Nine, 12, 22, 11%, 28, 7 number 3.
Now he is saying that interest part has been left out.
Yes.
Yes, what do you say on the interest? No, that part,
They can telemetry, they interest is.
no, that has not been rejected per se. He can be aggrieved if there was a rejection. It has not been considered. You can show cause will consider whether interest can be granted by a writ court. We can deal with that matter. Okay, we'll issue notice. Your book B. Fukan, hard 3 B. Fukan. When did you file this? When did you file this?
Sorry, one I will also file.
I was fine, I think that there one house from 600 to 600.
Yeah. Sorry.
600 actually, and I was, what is not on record?
I get the idea on record.
No, okay, no problem.
Okay,
They can be called.
okay. Sri B. Fukan, learned counsel for the applicant, and Hart Sri B. Fukan, learned counsel for the applicant, as well as Sri S. Bora, learned standing counsel. Water resource, Jal board,
I can all the.
all the respondents, para. Sri Fukan, the learned counsel, has however informed that an IA has been filed along with the review petition, which however is not listed. It's the para, list along with the IA said to have been filed.
Item 6.
Yes,
kindly come please number 11. The first ground, okay.
Review regarding what?
Okay, there is a, is separate of the picture.
Page 11.
Please look at the number 11. There it is.
Hmm.
For that, from people of the government and order that so and so, it appears that the government could observe that petitioners were appointed by the hospital management authority to city hospital and not by the Department of Health Services itself. But from the advertisement, it transferred that though the advertisement was issued in the name of hospital management authority Dhuburi, but there is a counter set of to Health Services Dhuburi.
Yes.
The response number 6 in his affidavit in opposition admitted the fact that the advertisement was issued jointly by the then District Commissioner Dhuburi and the Joint Director of Health Services Dhuburi. Then the final to subsequently level. Can we see the advertisement that is page number 46.
Hmm.
In the website looks, there is a counter.
We have seen that.
Yes.
Doesn't mean that it has been issued by the joint director.
So another thing is that, so see, page number 1131. Additional activity.
People one, yes. Yes.
Okay. Paragraph 3.
Hmm.
As per the MOU signed by the additional chief secretary, Health and Family Welfare Department, the Deputy Commissioner, Director General of Health Services, Board of India, the bar unit of Dhuburi Civil Hospital was started in March 2014, and the then District Commissioner Dhuburi and the Joint Director of Health Services Dhuburi jointly issued the advertisement published on Sunday, inviting application for engagement in the post of research, physiotherapy, driver, staff, promotion of the concept of bar unit of Dhuburi, Civil Hospital. Accordingly, interview was conducted and selected in the joint intent.
So we have to go by the records. Records, we have seen the advertisement. This is by the hospital management. There, somebody making incorrect statement in the affidavit, that will not change the records. This is the only ground.
Other grounds was I have taken, okay. But what is this ability to therefore, health services are coming. Additional like. And not to third ground what I have taken, okay, the annexure 31, 32, 33.
Page.
Yes, okay, page 77.
The first two grounds are the same. That you have just to substantiate, you have got
Yes.
taken us to the affidavit. Okay,
Yes.
third, the second one, 76. Yes.
7.
77, yes.
Yes. There is certain lots of communications, okay. It is from the Director of Health Services, Assam Hengravari. Address to the deficiency of the government of subject, proposal for creation of post for the bar unit of Dhuburi Civil Hospital under the National Program for Retention and Management of Bar Units. Reference to and so, sir, with reference to the subject and letter mentioned under reference, I have the honor to submit this proposal for creation of 25 number of posts for the bar unit of Dhuburi Civil Hospital, which was started under National Program for Prevention and Management of Bar Injuries since 2014. In this connection, a statement showing details for creation of posts and guidelines of MTB, MBI are enclosed here as per discussion in the meeting 6/3/2018 in the Secretariat District. There was it. Statement of 30, 79. Yes, 30. It was issued from the Deputy Secretary of the Government of Assam Health and Family Welfare Department to the Director of Health Service, Assam, Hyderabad is also subject furnishing of clarification. With reference to the subject cited above, I am directed to request you to clear in whether the proposed creation of post of burn units of police with hospital is for permanent engagement, absorption, regularization of contract with the staff.
Where is your counterpart today, Mr. Ahmed?
Yeah.
Where is the health department
Yes,
and union?
yes,
You have them. If you can make out a case, we may issue notice.
Yes.
Okay? We can have it day after tomorrow. Okay. Those three aged Ahmed, Mr. Qasim for the applicants is present, comma. There is no representation from the respondents. First of all, this court has however noticed that in the cause list, the name of standing council health has not been reflected. First of all, accordingly, the matter is adjourned for consideration on Friday. And the cause list should reflect SC Health and Family Welfare. Please inform them of.
Anjan sir, ma'am.
Yes, item 7. Sriram, you are there, Mr. Sekia? 8, 7 is also by Sriram. 8, Sriram is your name is there. 7 also your name is there. A Sekia, P Pegu, S Pegu.
This is actually in local law.
Hmm.
So the amount of it. Total amount is also 3,16,000.
What some error has taken place?
Yes, yes, sir. Yeah, on item 8 actually.
Item 8.
7, your name is there. 7, you look into the court file. You can do it. Okay, 8, you what is it?
Also hearing.
8,
Yeah.
7 also. No, you have a look. 8 you can press, 7 you can have it after some time. What is 8?
8 shows you compass capacity.
Hmm. Good.
No, it's 7.
8, okay.
Yes. Total amount is 3,16,660.
Item 8.
Yes, sir.
Hmm.
Compromise seat is also there.
Yes, then
But in the order also it is written as 6,33,603.
oh,
Amount is already deposited, so on that amount, both the parties are agreed to.
this is appeal file will the order amount 316. The agreed amount is 633,306, out of which 316,653 has been deposited.
So the agreed amount is 3,16,000.
Total.
Total.
Then why have you written at the outside at the out of the awarded amount 316,653 has been paid?
That is something. The compromise, it is there, also that is signed by the auditor of the company and the planning also.
The awarded amount was 633 something. Now what is the settled amount?
Lordship, that is 3,16,650.
But why was it submitted that out of this amount, 316,653 has already been paid? So remaining would be 316,653.
The compromise sheet is there. Lordship.
Where?
Yeah, I think
Compromise sheet to this. In the IA,
in the May.
main appeal.
So,
What does it all about? Again, Robert orders more message from it. You compromise in annexure A. Where is the annexure A? This is a
I, Lord.
no, this is pre-settlement.
Yes. Lord. In that amount, in this amount also, Lordship, the parties came and signed in the local level. It is here. I can hit.
Why the impression was given that out of the total amount which was awarded, this much was paid and this much, because this is not, this does not appear to be an inadvertent error. We have recorded that out of 633, 306,
That's what the 3,16,000. So 653 amount is written here. For the compromise.
okay, okay. Here for the other side, okay. Third, AGSIK, Learned Council for the applicant. Also heard, PDECA, Learned Council for the claimant. Full stop. The present application has been sought for, has been filed seeking correction in the order dated 8/3/2025, passed pursuant to an agreement and a pursuant to an amicable settlement reached in the local adult held on the same date. Full stop. It is submitted that though the settled amount was rupees 3,16,653, in the aforesaid order, the amount was written as 6,33,306. Full stop. The Learned Council has also drawn the attention of this court to the pre-settlement compromise sheet dated 14/12/2024, which has been annexed as annexure A to the IA, as well as to the compromise sheet SHET itself, signed by both the parties on 8 March 2025, wherein the correct amount of 3,16,653 has been stated. Full stop. Para. No? 8 to 8.
I not eight.
Para. The aforesaid submission has not been opposed by Ms. Jaka, the Learned Council for the respondent, who submits that maybe due to some wrong communication, the error has crept in the order. after considering the aforesaid submission and hearing the parties, the order dated 8/3/2025 stands modified by clarifying that the compromise amount is 3,16,653. 3,16,653 and not 6,33,306 as indicated. Mr. Para. Amount has been taken out. Deposited or not? Deposited. This court has been informed that the amount of 3,16,653 has already been deposited in the registry of this court, which may be released to the claimant on being properly identified by his learned counsel. Para. Statutory deposit already given back.
No.
The observation regarding refund of statutory deposit to the appellant company is kept intact. I accordingly stand disposed of. Para. Let this order be read as a part of the order dated 8/3/2025.
Same amount different, but there's. I'm sorry that I missed that.
7 to 8 আছে না? What should be the amount?
The total amount now, 3,57,267.
We do the exact account, huh? And some definitely wrong communication, because if you divide the total amount, it is half. The impression was given that the awarded amount was also itself compromised with will pay, but one amount was paid, the other will be approved. Same order, huh? Same order. Khali, that amount to 3,57,267. Our total going to 6 lakhs. Here to against 7,14,534. Correct? Same amount. Madam, you are also appearing in the same case. Okay. At a hearing. That's it. Okay. 57 to 6. Yes. I got taken to 8 to Mari. That's all. Yes, ma'am. Your matter. Medical matter. You be there day after tomorrow. Yes. Okay. You are not present. At Dubri Hospital. I think he was also there. No, he was not there. That burn unit. You've been served with a review petition. AZ Ahmed, burn unit. Those cases where T.J. Mahanta had appeared, were dismissed, some grounds have been made out. Okay.